All right, welcome to another episode of Justice for Y'all. I'm Paul Painter, and with me, as always, is Andrew Bowen and Stephen Morrison. Gentlemen, how are you?
Doing well. I mean, look at the podcast table.
Yep. For those who are only on the radio, it's Friday afternoon here in Bowen Painter land, and we've got a decanter of bourbon and a bottle of vodka that are helping lubricate the mind as we tell you the goings-ons in the world of law.
Buckle up.
Buckle up.
You're tuned into the podcast where justice meets Southern hospitality. Broadcasting directly from Savannah, Georgia, join your hosts, Paul, Stephen, and Andrew of Bowen Painter Trial Lawyers as they chat about the legal difficulties you might face in everyday life. From the ports of Savannah to the busy highways that stretch through the southeast, we're your go-to source for all things legal. Served up with a dose of Southern charm and commitment to justice for y'all.
Buckle up. So it's not a handle. What's the littler one?
That's a liter.
Liter. Okay, just a liter. Looks like a follower to me, but.
Oh, leader of the Tito's?
Yeah.
Terrible.
Yeah. We had the handle of Makers earlier. For those who don't listen all the time, we usually get like a nice bottle of bourbon and review it a little bit. Today we didn't have that, so we had a handle of Makers, which is, for anybody who doesn't know, it's kind of the trial lawyers of all ilks, just drink of choice. Everybody drinks Maker's Mark and generally ginger ale.
And if you don't, I guess you're not a trial lawyer.
That's right.
There's the other bar exam.
The other bar exam.
That's it.
All right. So
what are we talking about
let's
today,
get down
Andrew?
to what we're here about. All right. Last couple of episodes, we've talked about the plane crash, primarily the plane crash up in Washington, D.C., flight 5342, American Airlines, collision with a Army Black Hawk helicopter. We've also discussed the crash in Toronto of the Delta regional jet. But what I wanted to do today, because in those past episodes, we've talked about the facts as we have learned them, and questions about what happened. What I want to do today is let's talk about what are the claims that people have, who are the potential defendants, and what defenses might there be for these potential defendants.
I love that because we're kind of doing this the way we actually do with cases. We have the investigation phase, learning the facts, figuring out what happened and where and all those things, and then we take those and we apply them to the law.
Right.
And some of the questions we're going to have today are things that we have come up often, and especially in complicated cases, of what are the claims you want to file, where can you file them, which one is the most advantageous for your client,
Right.
Can you get jurisdiction there, what are the defenses, how do we prevent against those before we file suit, how do we plead the case so we don't walk into a trap, that kind of thing. So
as an example, and let's deal primarily with the Reagan National Flight 5342 case.
Yeah.
Obviously, there were no survivors to that crash. It seems like it was a pretty precipitous event. In other words, there's not going to be a lot of pain and suffering, although conceivably there were people who were alive and conscious as the plane plummeted to the Potomac River. But obviously there are wrongful death claims, okay? And so that's going to be primarily what we're talking about. There are at least two government entities that are potential defendants in this case, which raises all sorts of immunity questions, governmental immunity. So let's just talk about what if it turns out that the Army, through the actions of its pilots, is the at-fault party or one of the at-fault parties. What sort of claims can you file against the Army? How do you do it, and what sort of defenses do they have?
Stephen, why don't you take this one, the former U.S. Attorney's Office, AUSA? What do we do here?
Yeah, so this is it'd be under the Federal Tort Claims Act, which we have talked about before. This is an act that is a limited waiver of the United States sovereign immunity. So we've talked about sovereign immunity. Basically, the government cannot be sued unless it consents to be sued. Congress passed the Federal Tort Claims Act and allowed the government to be sued for certain tortious actions committed by its employees within the scope of its employment. This includes the military in certain instances. So the default rule is can't sue the government unless the government says it'll be sued. The government said it can be sued under the FTCA, so you follow the FTCA's rules to sue the government. One of the first things that you have to do is you need to identify the appropriate agency. So here it's the United States Army, Department of Defense. So you would file what we call a standard form 95. This fills out, it's a claim form it's a prereq to filing a lawsuit. You can't just go into a courthouse and file a suit against the United States because somebody that worked for the federal government did something wrong. You have to go through this administrative process first. It's technically an administrative adjustment process. Gives the government a chance to resolve the claim before a suit gets filed against it.
And we talked in state court claims, state claims that have sovereign immunity, that's often called ante litem notice.
That's
it's
right.
not called it there, but ante litem.
Which is a Latin phrase.
Which
Wrong
ones
button.
are?
I think that's it. I don't know. Andrew usually does the buttons.
Ah, yes.
Ante litem.
Sorry, I had to get the Latin phrase in. So ante litem is what it's called in state, but just it didn't call that
Before
necessarily
litigation. No, but it is. It is exactly like an ante litem notice where you say, hey, we've got a claim against you, government. Here is your chance to, your notification of it within the time period you've prescribed, and then your chance to resolve the claim. Now,
I'll say this. We have handled and do handle Federal Tort Claim Act cases, so we file these SF-95s pretty frequently. And I have to say, I don't think I've ever had the government come and actually try to settle a case when we've filed the SF-95.
no, it's not very usual. So what happens is you got the accident, you follow state law for this, or you follow state law for the substantive law, so like whether or not a person was negligent. But you usually have 2 years is kind of the default rule to file one of these. And when you file this SF-95, that tolls the statute of limitations, whatever it is. So if there's a 2-year statute of limitations in Georgia, then as long as you file that SF-95 within the period prescribed, the 2 years, and it's within the state statute of limitations, you can file suit for a certain period of time, indefinitely, until the claim is either denied or not responded to. If it's not responded to, you have 6 months from the date you submitted the claim, then you can file a lawsuit. Or if you wait for the claim to be denied, then you have 6 months to file a lawsuit after that.
And told just means it hits the pause button.
That's right.
The time stops. Yeah.
Yeah. So the other interesting thing about this is who you sue. So the SF-95, you have to identify the appropriate federal agency, and that's an important procedural step. And in this one, it's fairly straightforward. We'll talk about the FAA, but we're talking about the Black Hawk right now. So that was flown by U.S. Army personnel. You don't name the helicopter pilot. You put the relevant agency would be the Department of Defense, but the defendant in the ultimate lawsuit is the United States. You don't get to sue an individual under the Federal Tort Claims Act. If somebody didn't know this and they hauled in and sued, say, Captain John Winters, who was flying this, I don't know if that's their name or not, but just the captain flying the Black Hawk, then that would not be a proper defendant. One, you didn't follow the notice requirement, but then two, the United States has to be the defendant. So the United States steps in on behalf of all of its employees that are working for it. Right. Here, sometimes there are questions about whether this person was acting within the scope of their employment, like were they actually working for the benefit of their employer. Here, no question about that, because the Army was clearly doing an Army pilot, Army helicopter doing Army things.
Right.
Very clear that they were within the scope of their federal employment.
So in a case like this, the Federal Tort Claims Act permits the Army to be sued, or permits the plaintiff to sue the Army. There are circumstances, though, where you couldn't sue the Army. For example, if it was actually in a theater of war in a battlefield setting and the Army did something wrong, they have immunity for that.
They do. So we talked about default rules, sovereign immunity, unless the government says it can be sued. So you have this exception to sovereign immunity that says United States can be sued for, to the same extent that a private person doing the same thing would be sued for a person acting within the scope of their employment. But then that exception itself has exceptions, and you just alluded to one of the major ones, the combatant activities exception.
Right.
So there is an exception to the sovereign immunity waiver for any action occurring with respect to the military's combatant activities. Now, you guys are smirking. We have a case right now that is, on its way to the U.S. Supreme Court involving and a spinoff of this issue. We can talk a little bit about that. I don't want to get derailed on that.
I think we'd have another episode on that case because it's very interesting. But just quickly,
as much as we can talk about it, but yeah.
Yeah, so the firm represents a former service member who was injured during a suicide bombing attack. He was actually a hero, stopped the attack by intervening with this would-be suicide bomber. Several people were killed and injured on a Veterans Day parade over in Afghanistan. So we're talking about in an area where there's an active war effort, at least, going on. Maybe not a true war, but he was stationed over there.
Right. Bagram Air Force Base.
Bagram Air Force Base in Afghanistan. He was the bomber was employed by a federal contractor, so not the United States government. So, we sued the contractor in South Carolina. The district court where it was sued ruled that this exception, the combatant activities exception, basically applied to the federal contractor under this Supreme Court decision called Boyle versus United Technologies, that because there were federal interests that emanate from the combatant activities, it's an interest in the military's activities in a combat theater, that the state law tort claim for the negligence of the contractor allowing a suicide bomber that worked for them to build a bomb while under their supervision was then basically by proxy entitled to the same immunity, and the claims were preempted, meaning that because there's a federal interest here in the combatant activity of the United States military that included the actions of contractors like the defendant in this case and their suicide bombing employee, that you can't bring a state law tort claim against that contractor because the United States federal interests preempt those state law claims. Right. So we've taken that up to the Fourth Circuit and now to the United States Supreme Court.
Yeah, and we expect the petition for certiorari to the United States Supreme Court to be filed within a matter of days. Yeah. So be on the lookout for that. We once it's filed, we'll encourage any listeners to look up that petition and read about it. And for a dense legal issue, it's pretty interesting.
It is, yeah, because the facts of what happened are really riveting, and then you have, an interesting question of, okay, the government gets immunity. Well, if the government hires a contractor, how far does the government's immunity go to those contractors' actions? And as a briefing says, there's a split among the courts of the country of just how to handle that, and we're hoping the Supreme Court will clean that up for us.
All right, so we've talked about the Army.
Talk about our own stuff.
Obviously, it deserves an episode.
Yeah,
it does. Certainly when it's all
at
done,
least one. Right.
We
may
have multiple episodes on it. We'd write a book, but
so we talked about the Army. Anything else we need to add there regarding the claims against the Army?
Well, I want to talk a little about the combatant activities and how that could apply. So the main question here is really going to be, to what extent is the training operation of the Black Hawk pilots there a combatant activity? Now, it's going to have a lot to do. Courts have held that the pure training is not necessarily a combatant activity, but it's going to be really interesting. It's going to really come down to the nexus between what they were doing for training and the military's combatant activity. It was not in a theater of war; it was a training exercise.
Right.
It's not even clear that particular training exercise was connected to a combatant training. So it's not like they were running this route because they were about to go on a combat mission. As I understand it, this was a sort of yearly certification flight for this particular pilot or group of pilots. So it's really going to depend a lot on that. I frankly would like to be a little better prepared before I dive into the details of that. But whether or not, what it could mean is if a court came in and if the government argues this was a combatant activity, it would mean the United States is immune as only to the claim against the claim deriving from the actions of the Black Hawk helicopter pilot.
Right.
Now, let me just say, we're going to get into a few things with this incident, and it is what lawyers sometimes refer to as a law school examination question. And the reason for it is in law school, they give you a fact pattern that is often pretty convoluted, but it has a lot of issues you have to pick through to figure out what it allows you, if everything you're being taught in law school, to try to find something in there, and it has it.
And you may not come up with an answer, but you can discuss what all the issues are.
In law school, there's always a saying, there are no right answers. Of course, we learned that there are a lot of wrong ones.
That's right. Yeah, so you get this fact pattern like we have here. You've got a commercial aircraft coming in, two pilots on board. You got all the souls on board, and each of them could have an action that contributes to the whole circumstance. You got a Black Hawk helicopter pilot. You've got the pilots. You've got the crew that's on board. You got the people that told the pilots to go off and fly.
Air traffic controllers.
You got the FAA. You got immunity with two different government organizations. You've got the whole military combatant thing. And we'll get to this in a second. You have a crash that happened pretty much right between two different jurisdictions, between D.C. and Virginia. Yeah. So let me since we're on the immunity for the military, let me ask you this question, okay? Here's your law school exam issue that you got to come up with. So let's assume for a second that there was a member of the military flying on the jet on orders to go from one duty station to the next. So when
You're talking about the
those
Ferris
are-
doctrine.
I am. So those who aren't familiar, if you get orders to change duty stations in the military, they don't fly in a military plane necessarily. They give you a commercial flight. So he's on orders, or she's on orders, to go, and she's on this plane, and then the plane strikes a military plane. So can that service member's family bring an action against the Army if it, in fact, the Army was in some way negligent in causing this crash?
Well, you identified the Ferris issue, Andrew. So what do you see there?
Well, the Ferris doctrine says that active duty military cannot bring suit against the Army. There is an exception to that, but it does not involve
When it's incident to service.
Huh?
When it's incident
When
to
it's,
service.
when it's incident to service, which being transporting under orders would probably
Arguably,
be, yeah.
Would it? I mean, that's the question. It's like, it's pretty close, but it's also a civilian travel vehicle. So
Right. And you know, it may get down to how specific the orders were. You know, was the order specific enough to say, take this flight at this time? So
And the connection, but I mean, maybe the argument is the connection between the tortious Army members' actions and the orders, the service that the plaintiff service member was in. Right. So you've got a super remote connection between. There's really no connection, as far as we know, between this
it's just coincidental.
fictional service member who was on this plane at the same time. So I mean, that's a really interesting Ferris. I mean, Ferris doctrine is questionable itself.
Ferris comes from Ferris versus United States, a 1950s Supreme Court case, which extended this immunity to what we just said. A service member cannot sue the military for an injury in incident service. That's been challenged in recent years, and there's currently a petition for certiorari, which, if anybody doesn't know, that's where you ask the Supreme Court to hear your case. They don't have to hear all these cases. So you petition them to hear your case. And this one is pretty strong. You have, as I recall, it's a woman who's a service member who died in a base hospital while giving birth, and due to medical malpractice, and an Army doctor. And so it's like, well, it's like, I mean, yes, she was in the service, and she was at a military hospital, but this has nothing to do with her.
It's not incident to her.
Yeah, with the military, and so it's being good facts make good law. And these are terrible facts, I don't mean it like that, but good facts for the point you're trying to assert. So it's a good argument to say,
There's no
how is
real
this
common
possible?
sense reason.
That's what I'm trying to say, yeah. And so we'll see if the Supreme Court picks that up, because it's been heading in the direction that the Ferris doctrine may be reversed, which would be a huge
It's come under
change
fire
to- yeah.
quite a bit over the years.
Even the Camp Lejeune, everybody's heard about that.
Right.
I mean, that would ordinarily be the service members, not their families, but the service members wouldn't be able to bring a claim against the government because they were there on military orders. But there's a congressional carve out specifically for that, and they have the same thing as I think we probably talked about before, of kind of what we're talking about now, a medical malpractice type situation. Now they're allowed to make administrative claims, which is the same thing of.
Yeah.
But anyway, they can make claims.
We've
Let's get
once
back-
again gone afield.
Let's get back to Flight
it's good.
5342. Okay. What if the air traffic controllers were negligent in some way that caused this crash? What sort of claims do you have against the FAA and the air traffic control? I don't know if it's a separate organization under the FAA or if it's all just the FAA.
I don't actually know the answer to that off the top of my head, but I know that for those who are listening, watching, flight controllers, like the folks who actually make the calls, are employees of the federal government.
Right.
And they are folks that are under the control of, it's when they are giving directions, like that's going to be the question here is there some direction they gave or should have given that they did not give, or is there some policy? So one of the things that happened in this flight we've talked about is the change of the approach for the commercial airline, the American Airlines flight that was coming in, is how did that change jive with the policy? So if it was a policy that says don't make these kinds of changes at night, then that was the air traffic controller who made a negligent decision. But if the air traffic controller made a decision pursuant to a policy, this is where it gets really interesting, is how that policy was created may implicate another exception to the FTCA called the discretionary function exception.
Which we've talked about in other episodes, but
it can be if it's implicated, it can be a real challenge. So let's pin that for just a second. So, Andrew, you said, what can you do? You can bring a Federal Tort Claims Act for
Right.
the negligent action of an air traffic controller.
And so in that circumstance, we're back to a SF 95.
That's right.
And potentially, I would assume that lawyers representing people from this disaster are going to sue the Army. They're going to sue the FAA for the air traffic controllers. They're probably going to sue American Airlines. So all of them are getting sued. But they would have to file 2 different SF-95s, correct?
That's right. Yeah, and each claimant would have to file an SF-95. And so we talked a little bit. Let me say one thing about the SF-95. This is as a standard Form 95. You do not actually have to file an SF-95. It is the recommended way to do it, but that is not what Congress said. Use this form. It's just if you use this form and you follow the instructions,
you've complied.
you've gotten it right. But so when we talk about it as if it's what you have to do, it's not necessarily, but it's got all the information. You should do it.
Right.
So yeah, they would sue the FAA, and it would be a claim because you got to identify the right agency. So you have to identify the Federal Aviation Administration as the correct agency. You have to find the appropriate person to address that to, which is one of the real challenges in Federal Tort Claims Act cases, is identifying the appropriate agency. If you get that wrong, well, let me back up a little bit. What happens when you identify the agency? You got a claim. It is whether it's timely or not depends on the receipt by the appropriate agency. So it's not just like the mailbox rule we all know from law school, where if you just drop it in the mailbox rule, click the email, hit the fax button.
So I just filed one against the United States Postal Service, and so I couldn't just say United States Postal Service, Washington, D.C., and send it off.
Right.
Odds are, given the Postal Service, it's not going to make it there.
That's a whole other problem. Yeah.
Now that one you should be able to drop in a mailbox and it counts.
Okay.
Well,
I'm a little out of.
that's actually true, but
Yeah. So none of this is legal advice. You need to talk to a lawyer. Call us. That's fine. But my understanding and recollection is that you can actually deliver your SF-95 against the Postal Service to a mail carrier. I know you can take it to the post office.
Right.
I just can't remember if you can actually give it to
But
the mail.
let's put that quirk aside. What you really need to do is find out there's an address for the United States Postal Service. Actually, there's more than one because they have different areas.
It's called the FAA for this one.
Or for the FAA. And they probably have different areas too. They probably have a southeast,
That's right.
northeast, and there's an office specifically to receive these claims. And so you send it to that address. So that you have to do a little bit of sleuthing to figure out what that is, but the information's available.
Agencies that get sued a lot have this on their website. So like Veterans Affairs, they'll tell you exactly where to send it. It's very clear. The FBI.
You seem like you know that from personal recent experience.
Yeah, I may or may not have broken our firm's record filing an FTCA case.
We got one right at the last minute,
Yeah.
and it tolls the statute, and
So you gotta get it in there.
filed in about 24 hours.
Yeah,
Had
so
a courier deliver it in D.C.
I went with hand delivery on that one. When in doubt, hand deliver, and that one's always fun because I like to do a cover letter with ours so that it's the package that you deliver. You only need to get the claim with the right information. The appropriate agency, the sum certain, signature of the claimant, and the address of the claimant, and then the statement of the claim. Those are kind of the main elements that you have to get it there, and that can be on a freaking napkin. But I like to have it a little more polished and have my cover letter saying, here's this is the SF-95 enclosed. If you're a lawyer doing it, you have to have proof of your representative capacity. So I like to have that as an exhibit. We like to have a nice package here.
You put it together very well in a very short amount of time.
Well,
But let me just say, because we're getting towards the end of our time, one thing that we want to talk about is where the crash happened.
What
and
jurisdiction?
Now, what you have two. Well, we don't need to get into the whole jurisdiction, what all the different types are, but for the simple terms, one, where do you file the case? And two, what state law or what jurisdictional law applies? So who wants to walk us through this very tricky thing here? Because I think we have two definite options and then one kind of crazy option that could be done jurisdictionally and what law might apply.
For the airline, if the airline is a defendant, they can be sued where their place of business is.
Right.
So that's North Carolina for American, or is it?
Ooh,
I
that's
think they're in
Dallas.
Texas, yeah.
I think
They're
that's
in
Dallas.
Dallas.
Yeah.
Okay.
So you could file the suit against Dallas and Texas.
They bought United, which used to be in Charlotte. I
There
think.
you go.
And I'm not sure if you have jurisdiction for a non-governmental defendant in Texas, can you bring all the governmental defendants to Texas?
Well, venue would have to be proper as to the government defendant, and
Right.
so the venue for the federal. I mean, you'll have jurisdiction because if you have a federal court in Texas,
Right.
but it's going to be it's going to follow the same venue rules of where the accident happened, and I'm trying to now whether it's anyway. There'll be a question as to each of the relevant parties whether venue is proper against them. Against the government, it's going to be the location of the defendant. The government is everywhere, but you can't just sue.
Do you think Texas would agree that the United States has sufficient contacts in Texas?
That actually, this could be the case that declares the independence of the Republic of
There
Texas.
you go.
All right, but putting that aside,
Yes.
So you've got Dallas because American Airlines is headquartered there. For the government tort claims, generally you can sue the government in a federal court for the location where the incident occurred.
Right. The lex loci delicti,
That is a Latin phrase.
the law of the location of the wrong.
Right.
Just soak that in.
And that's it. No.
Okay.
So what is the location? There's some uncertainty to that because this was squarely over the Potomac River, somewhere between Washington D.C.
The collision was squarely over the river.
Right.
The tort is what we're talking. Is where you're. I'm jumping ahead, but
Yeah.
That's the questions you got to ask.
But right between Washington, D.C. and Virginia. So if the location of the collision is the determinative factor, then somebody's going to have to figure out, okay, was this on the D.C. side or on the Virginia side? And let's say it was the D.C. side. So then you could file it in the federal district.
in Columbia, a district.
District of Columbia.
Yeah, the District Court of the District of Columbia.
Right,
Yeah.
right. If it was on the Virginia side, you would file it in the district of, I would
EDVA,
presume it's, Eastern District of Virginia. But there's another factor here, Stephen, that you were talking about earlier that might not necessarily affect where you file it, but might affect the claims in other ways. Why don't you tell us about that?
Yeah. So one thing that some chatter has come up about whether admiralty jurisdiction applies to this incident.
Because it occurred over a navigable waterway.
Right. So the Potomac River is a navigable waterway. That's just a waterway that is traditionally used for maritime commerce. I mean, maritime law is all about maritime commerce. The Potomac River is historically and currently used for navigation of commercial and private vessels. So you've got a navigable waterway. The United States Supreme Court made pretty clear that just because an aircraft crash happens over a navigable waterway, even purely over a navigable waterway, does not mean that admiralty jurisdiction applies. This case is within 12 nautical miles, so you don't have the Death on the High Seas Act, which may apply when you are in international waters outside, and you have an air crash out there. We're not only within the United States territorial waters, we are within the territorial waters of either the District of Columbia or Virginia. And so you have a real question about, does maritime jurisdiction apply? Now, you're suing we talked about three different potential defendants. There's a fourth we need to touch on briefly, but the two government potential defendants, the FAA and the government, the U.S. Army, the Department of Defense, they can be sued under admiralty jurisdiction, but there is a different vehicle for suing the United States for federal torts involving admiralty jurisdiction called the Suits in Admiralty Act. In that case, you do not have the anti-litem provision that we talked about, the FTCA SF95 claim. So here's a weird thing that could happen. Say the FAA was not negligent. They did everything right. There's no claim against the FAA. The claim is against just the Army, and the Army and the reason that matters because the FAA, whatever they did, happened in the air traffic control tower, right? So it did not happen over the navigable waterway. So if it's just the Department of Defense that is the potential government defendant, and the crash happened over a navigable waterway, and the court determines under the executive jet case that I was talking about that maritime jurisdiction applies because the actions of the Black Hawk helicopter are a traditional maritime activity. Basically, the Black Hawk is doing things that maritime vessels ordinarily would have done before the age of the aircraft.
Ferrying people across the river.
Running a military training exercise up and down a riverway. So now you've locked in admiralty jurisdiction. Then the Suits and Admiralty Act could apply. And if the plaintiffs wait more than the statute of limitations to to file their lawsuit, it could be barred because, unlike the FTCA, claims under the Suits and Admiralty Act are not tolled by the SF-95. So that's why it really, really matters. One, if admiralty jurisdiction applies, and that a lawyer thinks about these things, because at DOJ, like in any defense, like you're looking for these ways,
to get out of the claim.
Yeah. This is
So in that case,
or if you're the government lawyer, to assert a defense in the interest of your client.
Okay.
Get out of the
To
claim.
get out
The
of the
people
claim.
of the United States.
So in this scenario, a lawyer has filed a SF-95 against the Army. He thinks, well, my claim under state law is tolled. The statute of limitations is tolled until that is dealt with.
That's right.
But if it turns out it is a admiralty or maritime claim, it's not tolled.
It's not told. And they could be forever barred.
Yeah.
And I had a case very much like that when I was practicing for the federal government.
And beyond just seeing that to anticipate the defense, it's something that figuring out what jurisdiction and what law you want to apply to your case. In a case like this, there's probably a good argument on several sides. So you think about things about what is the law of Virginia versus the law of DC versus
admiralty law.
Admiralty law. Which one best suits your client? Because there are
In admiralty, you have joint and several liability, so that any at-fault defendant can be charged with the entire amount of damages for the claim.
So here, there was an issue with the commercial aircraft, right, and they were part of the contributing, their negligence contributed to the death of these people, then if admiralty law applied, potentially the United States could be jointly and severally liable for the entire judgment against them, including.
If they were just 1% at fault.
That's
that
right.
could be the whole
Then if
thing.
99% was American Airlines, then they are liable for it. And it's up to them to go against American Airlines to get contribution.
And then you have questions about wrongful death. Each state has a different way to value a lost life. And depending if someone on that plane was a young person and a high earner of money, some states calculate that as the value of the life, how much you would have earned over a lifetime. Some people see it from the loss of your loved ones, how much is gone, how much those people lost is the value. And some people, like Georgia, see it from the value of the person themselves, how they see the life. And so that matters of
in
the
some
age
states,
and the
if
economics of your plaintiff, of which one might be better for you.
Some states like Florida, which isn't in play here, but Florida, if you're not earning any money and you don't have any dependents, the only claim is for any survivors, perhaps a parent, simply for their loss of companionship, love, affection. But if that parent happens to pass away before the end of the lawsuit, there is no lawsuit. There's no claim anymore.
And your life no longer has value in that lawsuit.
Right.
It's
But here's another thing, and I don't think this would apply to any of the passengers on the plane, right? Because nobody's going to be able to make a credible case that the passengers on the plane did anything wrong
to contribute to this.
But we happen to have one of the flight crew. The co-pilot on the American Airlines jet is from this area. And we don't represent him or his family, but potentially he has a claim.
Right.
And so the various jurisdictions treatment or laws related to contributory negligence would make a big difference as to his claim, because the defense, let's say we sue the Army and the FAA on behalf of this guy's family, they're going to point the finger and say, well, he had some fault in this too. And depending on the laws of D.C. versus Virginia, the jurisdiction could make a big difference as to how they see that. For example, North Carolina and Alabama have a 1% contributory or comparative negligence statute, where if you bring a suit and the jury decides that you are even 1% at fault, you can't recover anything.
Yep.
Other states like Georgia, it requires the jury to find that you were at least 50% equally at fault. And if you're equally at fault, they say, well, it's a dog fault.
That's the modified, right? Yeah.
And so that's going to be an important consideration.
And then some states are pure comparative, to where if you were 90% at fault and the other person 10% at fault,
you can still recover 10%.
recover 10% of what your damage is. So,
So it really matters what state's law apply and
what the circumstances of the actual client is.
right. And if it comes down, so say admiralty jurisdiction isn't in play, then you got to figure out where did the wrong happen. So if it was an FAA negligence, is it in the tower in Virginia, or is it where the collision happened over the Potomac? Then you got to determine where exactly was that moment of impact, or if it was the Army. What if it's both? What if you claim against the United States, one involving the Army's negligence, one involving the FAA's negligence? Is part of the claim based on Virginia law because the FAA was negligent in the tower over in Virginia, but the Black Hawk made a bad decision over the DC side? Really interesting stuff.
Yeah.
And that's good.
Honestly, the last one we talked a little bit about the commercial. I mean, that's pretty simple. Did the pilots make an error?
Right.
And what they were doing. But the fourth one was there an instrument failure?
Yep.
Was there some product that should have worked in a way that it
Right. Was there? Did the radios have some problem? Did the collision avoidance system fail in some way?
Or was it badly designed not to operate below 1,000 feet?
Right.
Is that a defective design?
And was that warned about to the Army by the manufacturer? We could go on with this for
and
days.
then are they entitled to immunity because the Army made? No, I'm just kidding.
I know. It is a maze of legal issues with this stuff, and it's you've got a tragedy that makes it so much more difficult for the loved ones who hear these things. I mean, these are pretty in-depth legal issues. I mean, this isn't something you really would see in a law school exam because, frankly, it's too confusing.
It's probably a
and there's
third-year
too many-
class or something like that.
Yeah, you're
It's
meshing
elective.
a lot of areas together to, not one class would have any of this, and even in law school. So, well, it is a tragedy, and hopefully these folks they will be well represented as they try to find justice for their loved ones who they've lost, and people who will be able to navigate these issues and find the right path. Because like we said, like law school, some of these things don't have a clear right or wrong answer. It's figuring out the best path to take for the best chance of finding justice. So. Anyway, our hearts still go out to all these folks who have lost loved ones. It's just a terrible tragedy. But anything else, guys, before we wrap it up?
Andrew, you got a joke for us? I feel like
we missed our joke.
We missed our
At least
joke
the
on the
last
last,
time.
at least the last two.
Yeah.
So.
Sorry,
Well,
Phil
put
was
you on
our
the-
joke, I guess.
That's true. The colonel was.
I did have a joke after Phil's appearance, but I don't think it's appropriate for general consumption.
Yeah, that's probably
not.
We'll have to satisfy the audience other times. So, it's a terrible set of circumstances. It's an interesting constellation. It will play out, and it'll play out very publicly. This is something that.
Yeah.
Aviation crashes on commercial levels usually get a lot of public attention. Have a little bit of understanding, I think. The NTSB investigation and the other involved agencies, the Federal Aviation Administration, the Department of Defense, they're also going to be doing their own internal investigations. American is going to be doing its own review. These things take time to play out. We lawyers, this is one way we cope with issues, and we hope that we offer something to someone who listens to this, or just for ourselves to talk about all the interesting issues. But there's a lot more to learn, and as we learn on that, we'll have a chance to engage with it a little bit more.
We'll try to update as we learn. This is just
figure out where the justice
saga.
for y'all is.
That's right.
Yep. All right, guys.
All right.
Good talk.
Good stuff.
Do
Happy
you
Friday.
have a joke for us, or are we?
No, he's.
Is
Well,
your
if you
presence
want
alone a
some,
joke?
did you hear about the guy that drank a whole barrel of invisible ink?
No.
Yeah.
He went to the hospital, but he couldn't be seen.
That's what we need. Nope, it's this one.
Yes.
Come on.
We asked for it.
Thanks,
All
y'all.
right. Thanks everybody for listening. We'll talk to you next time on Justice for Y'all. Bye.
Thanks for listening to Justice for Y'all, hosted by the attorneys here at Bowen Painter Trial Lawyers in Savannah, Georgia. If today's episode resonated with you, or if you find yourself needing legal guidance, remember, we're just a call away. You don't have to work through the difficulties of your situation alone. Visit our website at bowenpainter.com, that's BOWENPAINTER.com, or give us a call at 912-335-1909. We're here to serve you with the dedication and warmth only true Southern hospitality can offer. Thanks for tuning in, and don't forget to subscribe to our podcast on your favorite platform so you don't miss an episode. And tell your friends and family about us if they're ever in need of some legal insight. Take care, and remember that at Bowen Painter Trial Lawyers, we're committed to justice for y'all.